Morning, everyone. How are we all going? We have a reasonably full room. It is a pretty well sold out event, but here we go. Ladies and gentlemen, welcome. My name is Isaac. I'm the current president of NELA WA. It's a pleasure to welcome you all here today. Before we begin, I'd like to invite Vaughan McGuire to welcome us all to country. Please join me in welcoming Vaughan.
Good morning. Oh, gee, a bit taller than me. Good morning, ladies and gentlemen. As Isaac said, my name is Vaughan McGuire, and I'm the youngest sibling of 7 in my family. So 6 brothers and 1 sister. Even though she's my one sister, she still rules the nest to us boys. My dear father was, his name was Walter McGuire Senior, and my mother actually came from the Stack Rider Mippy families. Her father was actually born down here on the Guildford Grammar grounds, on the Bennebrook Springs, Guildford, and the Swan River. And I myself was actually born in a little town called Calabaron, and where I met Mr. Gardner outside. And lovely to know that he was born in Tamman. So, you know, we've had a lot of family and friends that have actually grown up through that area. But coming to Perth years and years ago, back in 1978, it was very, very challenging for me because we were leaving what I only knew existed as a little town called Calabaron. It was my only place of rest and understanding the countryside around there. Growing up, learning about all the regions, the men's country, the initiation caves. Even had the privilege of one of my great-grandmothers who took me to show me a ladies' cave just out of Calabaron. And very rarely would you ever walk in as a man into a ladies' cave. So I saw a lot of different paintings compared to the men. And but we were always raised with language. My father actually was a fluent dialect of 4 different Noongar languages that he actually spoke. And in the ways that he's actually brought us up, he's always been telling us the stories of the land. So when we actually came to Perth, my whole world was destroyed. I thought that was the end of everything. Leaving all my friends behind and coming to a place which I didn't even know. I didn't even think that anything would be bigger than Calabaron. And coming to Perth was a shock to us. When we first arrived, we actually went down to Highgate Primary School, and we were educated there, played football with East Perth and East Perth Highgate. And no matter how we grew, even in Perth, Bull, we always went back to Calabaron, and so we're up and down, you know, hunting and gathering and learning about stories and the environment and everything that my dad actually understood. My father wasn't educated, as I said. He grew up in the Great Depression, and when great-grandfather actually went off to the Second World War to fight with the 32nd Battalion. As Dad was 8 years old back then, he learnt a lot about country. And when we got to Perth, he was telling us that we actually came home to my great-grandmother's and grandfather's land. And my great-grandmother, Nellie Dulac, was actually born in Karakata, Kings Park, and happened to see the white sails coming up the Derbyl Yerakan. And so to us, it was a bit more of a friendly place because even though we grew up with all different people. The Chinese people, the Italian, Yugoslavian, Greeks. It was just amazing to find out that there was other races of people out there, and because all I knew was actually black fellas and white fellas in Calabaron, you know. So it opened my eyes up a bit more, and as we were sitting and listening to Father, he always spoke about law, Aboriginal law. And what it means, all the different stories within the star systems in the gender, which we call stars. All the stories about talking to you and talking to your hearts about the land and what the land has to offer, as Mother Nature has to us for 65,000 years. And I always wear the booker when I'm doing Welcome to Countries, because the kangaroo to us, the yonga, the marlu, the bigata and giddy giddy, the different names for the different types of kangaroos, but he's a keeper of the law for us, and he holds the law. So in learning all that process and where our placement is as Aboriginal people on country, we were never allowed to take more than what we could carry, only to provide us for the days, and every person within the tribe actually had a significant role to play every day, and that's to go and do what their role was. And then everyone actually were fed, looked after, and our law was very, very strict, and it still is till this day. So all I really can say is that, you know, Welcome to Countries really is all about giving people the rights to walk across this country. And to me, the country is still alive. It still speaks to us. And having the theme for NAIDOC this year was to heal country. And to me, I believe that's very, very strong, and we can't actually do it ourselves. We need each and every one of you to actually be standing with us, alongside of us, in front of us, behind us, as we share stories throughout the country, into giving information, stories and songlines, and sharing it as people, as human beings, because we need to actually unite and come together so that we can better the world, better the country for our children, our grandchildren, and our great-grandchildren, because it's very, very important. So Welcome to Countries are always constructed throughout Aboriginal Australia, and no matter where you went to and you came to the end of the boundary where your people came from, you had to get welcomed into the next area where you go. And this place called Bulu, Perth, was a place of very, very big trade back in the early days before settlement came. And a lot of the Ngalama Banja Mayinji people from the Pilbara system, the Wangata people from the goldfield systems came down. Our Pinjara people from down south, Pinjara, came up, and we all met along the foreshore. And that was one of our main, biggest areas to trade. And so it was unity of people coming together, hence the reasons why you would have a Welcome to Country every time people came into your land. And so when they developed down on the foreshore to stand with each other, the songs were shed. And today, after I stop talking, do the welcome, then I'll do a song for you fellas. And but it's about where great-grandmother was born, and in Kings Park, and it's the oldest song within the world related to a spider, a trapdoor spider. And we had the privilege to take it over to the UK back in 2018. My sons, my brother, and myself, and I honestly wish that we could have taken our bookers across there because it was that cold, you know. And for a bunch of blackfellas walking in London, England, I just looked at my brother. I said, you know, because it was really hard for us to breathe in our lungs. It was actually piercing our lungs. So couldn't wait for the end of the week. Performed 3 nights in front of 60,000 people each night. But the people of the UK were very, very respectful, and gave us more than we ever asked for, because they gave us a bunch of family. And as I said, you know, we still keep in contact with each other, but it's just lovely to meet people who were really, really interested in the oldest living culture within the world, with the oldest living stories and songs and language still spoken from our heart. So I stand here to do a Welcome to Country, and then I'll actually do the Trapdoor Spider, which is, before I do that song, it's about unity of people coming together. And when the spider weaves his web around us, and as he pulls on the web, it brings us closer and closer together, so we can actually stand united as people and walk our path on our journeys within our own lives. And quickly before I start, as I said, my father actually told me that he'd written the 7 books, and knowing that he couldn't read and write, he said to us that, "I've written those stories in your heart, my son." He said, "No matter where and what we've been doing ever since you can crawl and sit up," he said, "You know, I've always sat and spoke to you and you've listened, all your brothers and yourself. But those books, you're a living energy of mine. And what I've actually given you is knowledge and understanding." So we still walk every day in representation of my dear father, in preaching the stories that he gave us, and people like Cliff Humphreys from Kellerberrin, which he wrote a lot of stories into us too, old grandfather. So it's lovely to have that that connection with two of the old wisest men I've ever known, and to be part of their family. So yarn by yarn, Whadjuk ngany buja, nunok buja deman ka maman ka buja. Hello and welcome to Whadjuk country, my country, your country, our country, lands of my grandmothers and grandfathers who's walked these grounds before me. So as I'm standing here speaking and looking at you, you're seated with content and listening. My heart is strong, happy and proud to be here representing my people. So, have a lovely day, and we will talk another time. So, and it's about the trapdoor spider, and it goes a bit like this here. Wanare kan malana, wanare kan malana, poyongoda waningo, boyongoda waningo, wanare kan malana, poyongoda waningo. Wanare kan malana, wanare kan malana, boyongoda waningo, boyongoda waningo, wanare kan malana, boyongoda waningo, wanare kan malana, wanare kan malana, boyongoda waningo, boyongoda waningo, wanare kan malana, boyongoda waningo. Gee. So thank you. Have a lovely couple of days, and may God, the Creator, walk with you. And all we need to do is sit and listen to each other, because we've all got a story to tell. And if we listen to those stories, we combine them together, nothing can break it. So thank you once again.
Thanks, Vaughan. So, ladies and gentlemen, maybe just before we begin, we've got a fair bit of space down the front. If we've got new people coming in the door, Robin, if you'd like to come down the front, feel free. Alex is down here waiting. Ladies and gentlemen, it's been a couple of years since the last state conference, and there have been some significant reforms in environmental law and policy during that time. Starting with the bushfires in 2019 on the east coast, the reductions in emissions resulting from lockdowns in 2020, the shift in Australian banks, superannuation funds and insurance companies to curb lending and insurance investment in coal, as well as the various commitments by the private sector, state governments and even the federal government to reach net zero by 2050. It's fair to say the conversation around climate change policy continues to evolve rapidly. 2020 was also a year in which the protection of Aboriginal heritage was brought to the forefront of Australian and global attention, with the destruction of the culturally and archaeologically significant Juukan Gorge, right here in the Pilbara, Western Australia. Following what has been dubbed the Juukan Gorge incident, the Western Australian Government continues its efforts to reach consultation with the Western Australian community in regards to what the protection of Aboriginal cultural heritage should look like in this state. We've also had the Samuel Review into the Environment Protection and Biodiversity Conservation Act, as well as amendments to the Environmental Protection Act, which have been described as the most significant in 30 years. Today, we'll hear from a distinguished array of professionals who will share their expertise, views and their stories in relation to these legal policy developments. Ladies and gentlemen, it's a pleasure to welcome you to the NELA WA 2021 State Conference. Before we begin, in earnest, a couple of housekeeping points. It is a hybrid event today. I'd like to say hello to our online attendees. I think you can see my face from the camera in the corner, which is pretty impressive. Just on that point, ladies and gentlemen, we will have time for questions after each presentation today. If you could make sure you have a microphone in your hand when you're asking your questions, that'll mean our online attendees are able to follow. Maybe introduce yourself as well. First name would be great. If you have a phone with you today, please have it on silent. CPDs, please make sure you've signed the CPD register if you're claiming CPD points today. There is one on each table. You'll need to sign in and out at every session. You'll also need to provide your practitioner ID. Thank you, Legal Practice Board. And venue information, I have a little bit here. I think it's limited to. It's a non-smoking venue, ladies and gentlemen. You'll need to make your way down to Milligan Street if you'd like a cigarette. The male and female toilets are out the door, same level, halfway down the hallway on the right. If there's a fire alarm, a beep beep sound will sound. Please wait where you are until further instructions. And the fire exits are on this side, as we can see. Very good. So, I'd like to kick off session one, which is examining climate change law and policy, and introduce our keynote speaker for today, which is Ken Berlin. Ken, I'm hoping you can hear me. I can't see you yet. Yes, we can. Good morning, Ken.
Yes, I can. Thank you.
Excellent. Ken is a graduate of Columbia Law School and spent 44 years in private practice, concluding with 16 years as a partner at the US-based multinational firm Skadden Arps, where he chaired the firm's environment and climate change practices. Ken has been recognised as one of the top climate change attorneys in the world and has been chairman of the boards of the Environmental Law Institute and the Centre for International Environmental Law. Ken has also worked for the US Department of Justice and been extensively involved in environmental and climate change policy, notably as the chair of the environment team during the 2016 Obama presidential campaign. Ken was one of the two founders of the Coalition of Green Capital, a non-for-profit which has taken the lead in advocating for green banks, an initiative to mobilise philanthropic private investment in renewable energy and decarbonisation technologies. There are now over 20 green banks in the United States and other countries, and legislation is before US Congress, which is likely to be finalised this week and includes $27 billion for funding for more US green banks. Since 2014, Ken has been the president and CEO of the Climate Reality Project, which was established by former US President Al Gore to advocate and develop approaches to global action for climate change. The Climate Reality Project has has offices in 11 countries, including Australia. Today, Ken is joining us from his home Bethesda, Maryland, and will be presenting on addressing the climate crisis, the role of the US and Australia. Please join me in welcoming Ken. Over to you, Ken.
Okay, well, thank you very much. I really appreciate the introduction. I really appreciate the invitation to come speak today. Before I start, I just want to say a little bit more about my background and that I've spent a decent amount of time in Australia. When I was at Skadden, I worked on a number of transactions in Australia, including the big BHP Rio Tinto deal, where I would have done the environmental due diligence, but not failed. And I had one fun experience on it where I flew down for a 1 or 2 hour meeting, and then I flew back the next day to Washington. Quite a trip to do that. I'm also a very serious birder. I've seen almost 6,600 species of birds in the world. I've traveled all around Australia, and I've got a big trip coming up next October, a 23-day trip. We're going to cut right through the middle of the country and go to places that are actually very, very hard to reach. So I'm looking forward to that. But I'm here today because I think I'm really looking forward to discussion of climate change issues, because I think the United States and Australia really are in a fairly similar situation. In both countries, we've got very, very strong opposition to addressing the climate change crisis. Pretty evenly divided in our legislatures. And so we have very, very similar issues. And I'd like to approach that by first talking about, just giving a little bit of background about the Climate Reality Project, and then to really talk a little bit about why it's so urgent that we address this crisis now. And I won't go into too much detail, but I think I'll make some points that are very, very telling. I'll then start talking in the policy area by describing the Paris Climate Agreement, what it requires. I'll talk a little bit about why I think we can meet, I think we'll be successful in addressing the climate crisis. And then I'm going to talk about the US commitment and goals and the Australian commitment and goals, and some of the issues that we need to address. And then I'll talk a little bit about the legal issue in the US that could block progress, despite what we do on the legislative and regulatory side. We may have a unique issue there, but it's one that I just wanted to talk about because it raises very, very interesting legal issues. So to begin with, as you just heard, the Climate Project was founded by former Vice President Al Gore. Our mission is to build support for equitably addressing the climate crisis across all levels of society. We make that our mission because we think that we need to show our representatives that they have the public support they need to take the kinds of actions that are necessary to address the climate crisis. We build grassroots networks. We get activists speaking to them. We get public speaking to them. We want to show our representatives that if they don't act, there'll be consequences. If they do act, there'll be benefits to addressing this issue. To do this, we first train people in multi-day trainings to become what we call climate reality leaders. We've held 2 of these trainings in Australia. I spent quite a bit of time here around these trainings, one in Melbourne and one in Brisbane. The Brisbane was in 2019. We've trained a little bit over 2,000 climate reality leaders in Australia. When our trainings are over, we then work to engage and mobilize our climate reality leaders into a powerful grassroots movement. We've now trained around the world 40,000 climate reality leaders, and that number is growing rapidly. We have 1 million followers on our email list. We've got a couple of million followers on social media. So we really can build a powerful grassroots movement. And in the United States, and I think in Australia, we combine our work with many other groups. We're also, as you heard, an international organization with offices in 11 countries around the world. We have 131 chapters in the United States. Our offices around the world are in Canada, Mexico, Brazil, Europe, South Africa, Indonesia, India, Japan, the Philippines. We have some staff in China, and of course, in Australia. Now, with that, I'd like to talk a little bit about one of the critical things to know about the climate crisis is we need to address climate change now. It's urgent that we start now, and it's urgent that we address it. And I'll give you a couple of examples. The first is the International Panel on Climate Change, the international group of scientists working on this issue, just issued a red alert. They said prolonged warming, even beyond 1.5 degrees centigrade, could produce, and I quote, progressively serious, centuries-long, and in some cases, irreversible consequences. And critically, they say every bit of warming increases the risk. Editors of 220 leading medical, nursing, and public health journals said that health is already being harmed by global temperature increases and the destruction of the natural world. And if left unchecked, they said, rising temperatures, and I quote, risk catastrophic harm to health that will be impossible to reverse. And also without acting, we face major displacements from climate change related events of hundreds of millions of people, with all the associated human misery and all the associated national security risks raised by the kind of migration that results from this kind of displacement. And I think to really give you an example of what's happening, I think the next few charts really show it very, very simply and very dramatically. From 1951 to 1980, if you look at this chart, and this chart, by the way, is temperatures around the world, I think more than 20,000 data points, the climate was remarkably balanced. We had a good number of average weather days. We had almost an equal number of cooler than average and warmer than average days. That changed rapidly. From 1990 to 2000, you start seeing the curve shift to the right. We have fewer cooler than average days, fewer average days, many more warmer than average days, and for the first time, we're seeing extremely hot days. And if you jump forward to 2010 to 2020, we now see relatively few cooler than average days, much fewer average days, a large number of warmer than average days, and a very, very large number of extremely hot days. The extreme temperature events used to cover 0.1% of the land. Now they cover 22.1% of the land. It's not every day, but that means that 22.1% of the land has been subject to these extremely hot days. So when you hear about temperatures rising 1.1 degrees centigrade where we are now, this is the consequence of that. This is how that plays out in the real world. And of course, this is getting worse and worse every year, and we have to stop it. Another way of looking at it is to just look at this chart, which shows global surface temperatures from 1880 to 2020. And again, you see the dramatic increase in warm days, in warmer than average days. Now, there are a lot of reasons why climate change really requires us to act. And we really require to act first to reduce climate risks. Physical risks to investments and to the economy from raging storms, wildfires, flooding river valleys, eroding coastlines, heat waves, and droughts are obvious. I don't really need to talk about it in Australia. You've suffered from that terribly, as we have and are in the United States. One example is that 25% of all critical infrastructure in the US, according to a recent study, is at risk of failure due to flooding. That's an amazingly high number. And of course, these events threaten corporate operations and supply chains, and therefore the whole economy. The cost of climate change, the cost of these events, is also very large. The estimate is in the United States that in 2020, these events cost about $99 billion, and that number is going up rapidly. There are also transitional risks and stranded assets. We are going to convert to a clean energy economy. It's inevitable, as you'll see, because of economic reasons. It's inevitable because of climate change. How fast we'll do it and whether we do it fast enough is an issue. But while this transition is taking place, fossil fuel businesses are all going to start seeing their businesses threatened. They're going to probably see their profits go down. There may be blips, but it's going to affect their businesses. That creates risks to the economy, to their investors, and to their workers. And of course, it's the risk of stranded assets. Fossil fuel companies record proven reserves on their books. Those proven reserves are much, much greater than the amount of coal, oil, and natural gas that they'll be able to draw from the ground. At some point, they'll have to start taking out those assets and taking losses to replace that. That, according to a study just finished this week by the United States Financial Stability Oversight Council, creates a systemic risk to the finance system. So we really have issues we have to deal with. We have to figure out a way to unwind this without harming the financial system too much. Employees and consumers want action on climate change. If we don't take it, they'll be dissatisfied. And to put the health issue another way, the single greatest threat to health, according to the World Health Organization, is climate change. We should also act because climate change creates critical ecological risks. Climate change disrupts ecosystems, threatening agriculture, forestry, and the resources on which we depend. It threatens water supplies. It threatens coastal barrier reefs, which not only protect communities from storm surge, but have great economic and biodiversity value, and it threatens biodiversity. We risk, according to studies, the extinction of 50% of all species from a number of risks, but primarily now from climate change. And by the way, the bird in this picture is found in both Australia and the United States. It's a great egret. There are also, though, on the opposite side, substantial economic benefits that will result from transitioning to a clean energy economy. First of all, as I'll explain in a minute, renewable energy and clean energy are becoming far cheaper than fossil fuels-based energy. So countries and companies that transition to clean energy will have a competitive advantage. Their goods will be cheaper, and they will be able to outcompete businesses and countries that don't do that. There also is a tremendous market opportunity. I recently heard Janet Yellen, our U.S. Secretary of the Treasury, say the transition will require an estimated $3 trillion of investment per year. That's $3 trillion of business for companies that try and become involved in that, try and sell products related to the transition to a clean energy economy. Will have a gigantic market. This may, in fact, be the largest market driver we've ever seen in history. So there's tremendous market opportunity. The opposite of what I said before, employee and consumer satisfaction will increase. And if we transition to a clean energy economy, it will enable a just and sustainable economy. It will enable us to address the disproportionate impact that fossil fuel production has had on poorer and disadvantaged communities. And if we do it right, we will not have that impact from the transition to a clean energy economy. With that, let me turn to the Paris Climate Agreement, because that's the signature document in which the world has expressed what it wants to do about climate change. The document was signed in 2015 by 197 countries, and now 193 countries that represent 97% of the world's emissions have ratified the agreement. The agreement has 4 pillars, and I'm going to talk about 3 of them today. One is it sets long-term goals, and of course these are critical as we look at what we have to do in Australia and the United States. It then asks countries to make commitments to reduce their emissions. Those commitments were called nationally determined contributions. It had a 5-year review of those commitments, and then it had provisions on transparency, which I don't have time to talk about today. So let me take the long-term goals. The goals set forth in the Paris Climate Agreement was to hold global temperatures to well below 2 degrees centigrade or Celsius, while pursuing efforts to limit warming to 1.5 degrees Celsius. Since then, in the last 5 years, the science is showing, as you heard from my quote on the IPCC report, that we need to limit warming to 1.5 degrees Celsius, or as close as we can to that. The second goal was to achieve net zero emissions in the second half of the century. And again, we've learned that really the goal should be to achieve net zero emissions by 2050. And that's the goal being set by many countries around the world. So what are NDCs? Under the agreement, every country had to make a commitment to reduce its emissions. There was no number set. Every country could do what the country thought was appropriate, and the agreement provides that developed countries, who of course more of the climate change emissions than developing countries, had a greater responsibility to address this issue. And of course, there are countries in the middle, like China and India, the first and third largest generator of climate change, that also have great responsibilities to do that. So countries set their commitments in 2020. They were called nationally determined, in 2015 and 2016, they were called nationally determined contributions. And as part of that, they were supposed to set a roadmap to achieving the goals they set in that NDC. And finally, when the parties were negotiating the agreement, they knew that the NDCs they were going to get in 2015 and 2016 would not be adequate. They knew that if fully implemented, the commitments would only limit global temperature rise to between 2.4 and 3.8 degrees Celsius. And that assumes everybody fully implemented their commitment. But countries recognized the shortcomings, so they agreed to review progress and issue new commitments every 5 years. It was supposed to be done last year in 2020. The Conference of the Parties was delayed because of COVID to this year. The conference is coming up at the end of this week. countries are making their commitments now. It looks like we're still going to be short of where we need to be by a considerable amount. We'll have another review in 5 years, and in the interim, we'll still work to try and strengthen commitments. Now, I'd like to turn to how the US and then Australia are trying to address these issues and what are our goals? How do we meet the commitments we're making under the Paris Climate Agreement? And how do we meet the commitments we need to make to address this issue? First of all, one of our goals is a just and equitable transition to clean energy. I discussed that previously. It's central to the work we're doing in Climate Reality. It's central to the work of the environmental community, and many law firms, of course, are working on this also. The United States has set a new nationally determined contribution this year of a 50 to 52% reduction of emissions from 2005 levels by 2030. Our initial NDC was a 26 to 28% reduction by 2025. So we've almost doubled that commitment. And I'll talk in a minute about whether we can meet that commitment. Making a commitment alone is meaningless unless we have the ability to meet it. And I'll talk about whether we can do that in the United States. We also set, we've also set internal U.S. goals to both help us meet the NDC and to meet our broader emission reduction goals. So by 2030, we, consistent with our NDC, have a goal of the Biden administration and most environmental groups to reduce greenhouse gas emissions by 51%. But a key part of that is a commitment to an 80% reduction in emissions from energy generation, energy generation by 2030. That's a major commitment. We think it can be met, but it's going to take a lot of work. By 2035, our goal is 100% clean energy generation and 100% sale of new electric cars. That means no energy generation by fossil fuels, no energy generation by coal, unless people can come up with carbon capture and sequestration that captures most of these emissions, and that has a ways to go. So we have set very ambitious goals by 2035, and by 2050, our goal is net zero emissions of greenhouse gases, consistent with the Paris Agreement. Now, let me start by looking at whether we can, in fact, achieve this. And the reason we're confident we can achieve this is because there's been a revolution in the cost of renewable and clean energy since, well, really in the last 10 years. But going back to 2014, in 2014, electricity from solar and wind was cheaper than new coal and gas plants in approximately 1% of the world. In 2019, just 5 years later, solar and wind provided the cheapest source of new electricity in 2/3 of the world. And the estimate is that by the end of 2023, in 3 more years, these sources are expected to provide the cheapest source of new electricity throughout the world. And it's more than just new electricity. Studies in the United States show that today we could close down over 75% of our coal plants, replace them with clean energy, and the energy generation would be cheaper. Now, I don't want to minimize that even though wind and solar are cheaper, that there aren't still issues. There's still issues in transmission. There are still issues in connecting all of this. And so there are issues that have to be dealt with. But we will see cheaper energy from renewable energy and clean energy throughout the entire world. And obviously that will have a major impact and will make this transition possible and economically beneficial. An example of that is if you look at the levelized cost of electricity in the United States, you see the cost from 2009 to today, see the cost of coal and natural gas, nuclear. Wind started higher and now is lower than all three. Solar started very high and is now lower than all three, much lower than coal, a little bit lower than natural gas, but the curve is going in the direction of cheaper and cheaper renewable energy. Again, there's some issues on part sourcing and things like that, but the cost is going to continue to go down on clean energy. And again, that makes this transition economically viable and advantageous to people, to the countries and corporations that do it. Same thing is going to be true with electric vehicles. There we need the electric vehicles to reach price parity. By 2022 in the US, Australia, and Europe, parity will be reached for larger cars, and the US and Australia for SUVs. By 2023 in the US and Australia for all segments of the car market, and in China for mid-sized cars, and by 2024 in Europe for SUVs and mid-sized cars. Just this week, Hertz, the car rental company in the United States, announced they were buying 100,000 Tesla electric cars. They're a commercial business that depends on being price competitive, and the fact they're buying these Teslas is a very strong example of how electric vehicles are going to reach parity. I have Teslas. They're more fun to drive. They're faster than internal combustion engines. They're cheaper to operate than internal combustion engines. They have far fewer moving parts. They're cheaper to charge. The cost of charging is less than the cost of filling up with gas. So I think the transition to 100% sales of new electric vehicles will go quicker than people think. It'll take a long time to get existing cars off the road, but we will make progress on new vehicles. And just one other example of this, in the United States in 2020, 80% of all new electric generating capacity was from wind and solar. Now, how are we doing this? We still need to pass major legislation in the United States to make sure this transition happens and to help it along and make sure it happens quickly enough. The U.S. Congress has passed one major bill called the Bipartisan Infrastructure Bill, and is expected to pass a second bill this week or next called the Budget Reconciliation Bill. We know it's in the Bipartisan Infrastructure Bill. It's going to have about $120 billion for transportation and $55 billion for clean water. Not all of this is going to go to clean energy, but most of it will. The reconciliation is a big piece of climate change related legislation. We're hoping we'll get a final bill on that literally almost any minute right now. If you see on this chart, I put up numbers, 200 billion for clean energy, 20 billion for energy efficiency, et cetera. It looks like, though, what we're hearing, and I don't know for sure, the current feeling is the bill is going to include 500 billion to 550 billion for investment in clean energy, renewables, automobiles, clean manufacturing. That is a massive investment if that takes place. So we have our fingers crossed that that will in fact happen. Now, there was one provision left out of the legislation that would have set time deadlines for the clean energy transition. That was dropped from the bill because of opposition from one senator in the United States. We're 50-50 divided on this. And if one Democrat votes against it, we can't get the bill through. He made the sponsors take out a provision that, as I said, would have set time deadlines. That would have led, and if the time deadlines were not met, the utilities would have suffered and had to pay a penalty. That would have helped force the closure of fossil fuel-based plants. It's not going to be in the bill, but we still have this massive investment in clean energy. Now, the question is, can this bill get us to where we need to be in 2030 and get us to where we need beyond that? Taking out the provision I mentioned makes it harder for us. But a recent study concluded the U.S. can meet its 2030 goals by supplementing the 2021 federal legislation with federal regulations, state legislation, corporate action, and individual action. I won't talk about the individual action today. And also, of course, we can come back in 2023 and 2025 and try and put these deadlines back in future legislation. And that, of course, will be our goal. If we look at federal regulations, I won't go through it. This was the conclusions reached by the Rhodium Group, a respected group that did this study. The federal government in the United States can adopt regulations that really deal with emissions from factories, from electric generating units. They can put measures in that may force these units to close. or adopt carbon capture and sequestration. They can put standards in for more efficient vehicles, vehicle mileage standards that would lead to 100% clean energy. They will have requirements for industrial sources, oil and gas production, equipment performance standards, et cetera. And we have a government here in the Biden administration that's very pro-climate change. It will work to adopt many or most of these. It's working on these right now. So we should get very strong regulations in the United States. I'll talk a little bit about what legal issues those raise. On the state level, states have also taken action. 26 states, plus the District of Columbia and Puerto Rico, have set 100% clean energy targets. Their targets are later than we would like. They're 2045 and 2050. We're going to be working, in the environmental community will be working to try and set those targets back to 2035. But the important thing for now is 20 of those states have set a 40 to 70% reduction target by 2024, between 2024 and 2030, thus meeting our commitments, hopefully enabling us to meet our commitments of a 51% reduction by 2030. And 3 states have set targets later by 2040, but an 80% reduction. And in the United States and around the world, corporations are acting. Over 300 global companies have made a commitment to 100% renewable, and we will be working, and more companies will do that in the future. If I can turn to Australia for a minute, Australia's current NDC is a 26 to 28% reduction from 2005 levels by 2030. I'm in the United States, but from everything I'm reading and from my office, I understand that Australia is not expected, I think they've said, not expected to strengthen this NDC, which was their original one, this year, or to do so only marginally, although the government has said that they think they will exceed the 26 to 28% rate because of the actions that businesses and consumers are taking, not because of anything the government does. The government is also considering setting a net zero goal, and I think they may have announced they're doing that by 2050. But again, it's not clear if there are any interim reduction goals, and without those, of course, that 2050 number is relatively meaningless. Like the United States, to really be in line with a 2 degree Celsius limit, Australia needs to reduce its emissions by about 50% relative to 2005 levels to 2030, and must reach net zero emissions by around 2045. If it was to keep it at 1.5, the commitment would be greater. We'd be very happy with 50% right now. And of course, there are many ways that Australia can act to close the emission gap and reduce emissions. Australian states and territories are acting. Every Australian state and territory has set a net zero emission target of 2050, and many of them do have interim targets. Some of them are very, very strong and targets that will help move us along. And as we did in the United States from 2016 to 2020, when Trump was in office, we concentrated at the state level to pass the legislation we needed, waiting for our opportunity this year to work at the federal level. And although I'm not generally talking about what individuals are doing, I did want to say that more than 2.6 million residential properties in Australia now have solar systems installed. That's more than 1 in 5 homes. That's a world-leading level of work, and we praise, obviously, Australia for doing that. With that, let me talk a little bit about the standards of review for legislative administrative action, because we're worried in the United States about upholding whatever we pass on legislation, whatever regulations we pass. And I'll explain why by first talking a little bit about current law and then talking about what might happen. As I think you know, we have a very, very conservative Supreme Court that we're concerned about. So there are really 3 different sets of issues that I'm going to mention briefly. How does an agency interpret a statute? Once the agency passed a regulation, what kind of standards it have to meet in order to have that regulation upheld, and what deference is owed to the agency. So So let me start off with how agencies must interpret a statute. I'm not going to read through all this and go through all that, but the bottom line of this is that that in interpreting a statute, an agency must pay attention to the wording of the statute. It obviously doesn't have carte blanche to do whatever it wants to do, but it does have the ability to deal with ambiguity in the statute and make decisions that are consistent with what the statute is intended to do. In the Massachusetts versus EPA case, the case that upheld the ability of the EPA to regulate greenhouse gases, the statute said that you could regulate any air pollutant which may reasonably be anticipated to endanger public health and safety. And the definitions but it then went on to define air pollutant. It talked about welfare under that, which it defines including effects of weather. But in the actual list of pollutants, there was a list, there were no greenhouse gases listed. So what could you do? What could EPA do? EPA, relying on the endangerment findings, said that greenhouse gases are pollutants that endanger public health. They're caused by weather in part, and the Supreme Court upheld that. Again, it said you have to pay attention to what the statute says, but you can do a reasonable interpretation consistent with the science. And there's more detail on that on this slide. I'll just leave it up for a few seconds and then go on to the next slide. Okay, why don't we go on? The next issue is, how does the courts in the United States review agency decisions and agency rulemaking? And basically what the court says is they have to take a hard look at regulations. They want to be sure that when they look at an administrative record, there's reasoned decision making, that the agency did not act in an arbitrary and capricious way, and that it considered all relevant factors. This is a decision that we are very comfortable with in the environmental community. During the Trump years, where they really couldn't justify the regulations that they were promulgating on climate change and other issues, as many as 91% of their regulations are being overturned. We're confident that we can build administrative records that meet the test in this of the Supreme Court, that the regulations can survive a hard look, that they are not arbitrary and capricious, they consider relevant factors, and there was reasoned decision making going into that. If we can change slides. Then the final issue is how much deference is owed to an administrative decision. Judges, as the Supreme Court held, are not experts in the field, and the interpretation of statutes, they said, really centers on the wisdom of the agency's policy, and thus deference is appropriate. And of course, regulatory schemes are complex, and you do need that kind of careful analysis that an agency needs to do. I think all of these are very, very strong tests. They're positive tests, they're fair tests, they're tests that we are confident we could meet, at least with the Supreme Court, up until the last year or two. We're worried about what may happen in the future, though. If we can go to the next slide. In the Massachusetts v. EPA case, the EPA argued that because the statute was general and pollutants were defined, the agency did not have the authority to regulate greenhouse gas emissions. The Supreme Court turned that down, and it looked at the relevant underlying science and was satisfied with what the EPA had done. But we have a new, very conservative Supreme Court, and we're worried about the kind of criticism we're getting from Supreme Court Justice Gorsuch. He said that agencies, if not stopped by the Supreme Court, may make decisions based on their own preferences about optimal public policy when a statute is ambiguous, or even more strongly says an agency can seek to pursue whatever policy whim may rule the day. Now, what are going to be the consequences of that? I don't think he's going to be able to say that there is no deference given, but we're worried the Supreme Court is going to say that when a legislative statute is interpreted, the EPA or other agency doing this can only do exactly what the statute says. If there's any ambiguity, they can't fill in the gaps in the statute itself. And of course, there's ambiguity in every statute. My guess is reconciliation bill will be thousands of pages long, a lot of it drafted on a very short time notice. And the agencies, even when they have reasoned decision making, they're not arbitrary and capricious, they may be making decisions about how you interpret ambiguous provisions, and this Supreme Court may overturn those. So we have to wait. We don't know for sure what's going to happen. We'll try and work against that. We'll try and make the statutes as specific as we can so that doesn't happen. But that's a potential issue affecting us. So with that, I want to conclude by just reading a statement by the author Thomas Friedman, who's written a lot about this and a lot of other things. He says, clean power, clean cars, clean manufacturing, and efficient buildings make everything we want to achieve in our society easier. They can lower our healthcare costs, cut heating bills for the poor, drive 21st century innovation, foster decent jobs, mitigate climate change, create more competitive export industries, weaken petro-dictators, enhance U.S. national security and moral leadership. And this holds true for Australia and other countries around the world as well. So with that, I'll stop. I thank you. I'm happy to answer any questions within the time limit that we have.
Thank you, Ken. We have a little bit of time for questions, not a great deal, but we have one that's coming online, but we might touch on first. This is a Building Back Better Act specific question, Ken. So it comes from Matt Whiting, a NELA member from online. Can you comment on the likelihood of a methane-free approach will be placed on the emissions from the oil and gas sector via the Build Back Better Act? What difference would it make if that change was accepted?
Yeah, I don't think so much, at least in the United States, the legislation, as I said, without this provision that was taken out of the bill, will directly affect and regulate the oil and gas sector. Now, we're going to do that probably by regulation in the United States. But the key thing to remember is this is all going to happen economically. We're going to see, again, a transition to electric cars because they're going to be cheaper, they're going to be better. We're going to see a transition away from fossil fuel-based energy generation. We want to encourage that. That's why we want to put in all these incentives because time is of the essence. One thing to remember about climate change, which makes it unique, is we can do a tremendous amount and still fail completely. We could cut emissions by 50% and still fail, and we could still fall into the trap that the IPCC says we will be doing things that we can't reverse that will affect us for centuries. So we need to do this quickly, and we're looking for incentives to move things along more quickly. We are looking for regulations that could affect the oil and gas industry and the coal industry, and we'll be pushing for that. And I think in the long run, we're likely to get it.
Wonderful, thank you, Ken. We have time for another question, and I'll turn that over to our in-person audience today. Is there a brave soul who would like to ask? Thank you.
Hi Ken, thanks for that. I'm Claire Lakewood, actually work for US NGO on these issues. Just for a little bit of context, you've talked a lot about the regulatory options for controlling greenhouse gases, but nothing yet about the opportunity that the Biden administration has to use executive powers in denying permits for fossil fuel projects. Wouldn't that be a swifter, very defensible way to rapidly decarbonise and prevent any future fossil fuel build-out?
Great. Well, very good question, because, you know, in the United States, as some of you may know, we have a tremendous amount of public lands that are regulated by the federal government, and there's a tremendous amount of oil and gas exploration on those and coal production from those lands. So there are permits coming up. So far, the Biden administration has been granting a lot of these permits. It arguably has no choice in some of these. There are court decisions that have held they have to grant some of these under existing statutes. but there is obviously a major effort by the environmental community to stop these oil and gas leases. We're arguing, among other things, that these are likely to lead in the long run to stranded assets, and they won't be good investments. They will ultimately hurt the economy, even though companies may be able to get benefits from them in the short term. But so far, there's not been, by the Biden administration yet, the kind of regulation of that we would like to see.
All right. Thank you very much, Ken. Ladies and gentlemen, to keep us on track, I think we will need to move on. But thank you very much, Ken. I'd like everyone to join me in thanking Ken, and wish you the best of an evening, Ken, over there. And thank you very much again for your time.
Great. Thank you, everybody.
All right. So, ladies and gentlemen, the first surprise of the day. Your booklets tell you that David Hodgkinson is presenting next. Unfortunately, David is unwell, and he was unable to present today. So, fortunately, we have had Alex Gardner, who's just stepped out of the room, agree that he will step in and present. I'm sure he's just going to wander in, so I'm going to introduce him. Alex Gardner is a Professor of Law at the University of Western Australia, where he teaches administrative law, environmental law and water resources law to Juris Doctorate and postgraduate students. He previously taught constitutional law, mining law and comparative law, and was the Director of High Degrees of Research at UWA Law School from 2017 to 2020. Alex researches in natural resource and environmental law and has been a contributing editor to the Environment Planning Law Journal since 1993. And he was also the editor of the Australian Resource and Energy Law Journal from 2012 to 2017. As he makes his way to the front, Alex, you can fact check me on this one, but a little known fact about Alex that he can fact check me on was, Alex, I understand you're one of two lawyers that brought one of the earliest successful judicial review cases challenging the lawfulness of old growth forest in Western Australia during the 1990s. He's nodding, so I think that's right. There we go. So today, Alex will be presenting on licensing greenhouse gas emissions in Western Australia. Please join me in welcoming Alex to the stage.
Sorry, I just check the technology here. As I understand it, there's can I control things with this one?
You can. Yes.
Great, thank you very much. Greeners go forward and redders go back. Great, thanks very much. Well, thank you very much to NELA and Isaac for the opportunity to make this presentation. May I begin by just expressing my personal gratitude for the welcome to country from Vaughan McGuire. This morning I had the pleasure of meeting Vaughan at the door. We both went to one of the locked doors to start with, and we discovered that we were neighbours effectively from Tammin and Kellerberrin, and that he knew people that I knew, including a friend of mine from primary school and high school, whose daughter Emma Garlett is now on the program today, and what a great pleasure it is to have all those connections. I want to begin by just reading from the abstract of the article that I published in May this year with two of my fabulous environmental law students from UWA, Olivia de Kooning and Helena Nguyen. The past and current practice in Western Australia has been not to regulate greenhouse gas emissions by licences issued under Part 5 of the Environmental Protection Act of Western Australia, because such emissions do not cause pollution or environmental harm. This view should be reconsidered in light of the post-Paris Agreement characterisation of greenhouse gas emissions, and because the Environmental Protection Act Amendment Act 2020 inserts a new section 74 A sub 2, providing that, quote, a licence does not authorise an emission unless the emission is specified in the licence as an authorised emission. The amendment may affect the scope of the key defence to the offences of causing pollution and environmental harm, that of acting in accordance with a licence, which we call in the article the licence defence. It is arguable that Part 5 licensees with substantial greenhouse gas emissions may need to apply for licence amendments specifying the extent of those emissions to secure the licence defence. Now, the article goes on to explore this argument in the context of a case study of Yarra Proprietary Limited, which has licenses to operate its fertiliser plant and technical ammonium nitrate plant at the Burrup Peninsula near Karratha. Now, I'm not going to attempt to talk about the case study in this presentation, rather just the basic argument, are substantial greenhouse gas emissions pollution or environmental harm, and the licence defence, and possibly other defences. Now, I acknowledge as well one of the limitations of scope in the article is that we only address one element of what one might define as the features or the elements to be addressed in showing an offence of pollution or environmental harm, and that is firstly the physical element. You know, do you basically meet the definition of the circumstance of pollution or environmental harm? We don't go on to address questions of mental element or corporate criminal liability propositions or defences. So it's not a complete analysis, and I'm not suggesting that someone rush off and prosecute Yarra just yet. Now, what I am trying to do then is to look at those three basic points. Are substantial greenhouse gas emissions equal to pollution or environmental harm under the EP Act? And I want to start with the state's redundant legal analysis that is still being applied, and then refer to what I call the legal tipping point of the Paris Agreement on the 12th of December 2015. Then I'll look at the licence defence as it currently applies. It is currently an implied authorisation to conduct activities that may include greenhouse gas emissions, even if there aren't specific conditions about greenhouse gas emissions. But with the amendment of section 74A2, we suggest that there is a future express authorisation requirement. And then I'll briefly finish with other defences, particularly the operation of Part 4. So, if I turn first to substantial, are substantial greenhouse gas emissions pollution? And in the article we refer to two potential levels for a court in interpreting these definitions to say, yes, those emissions are substantial. One is the level of the 25,000 tonnes of CO2 equivalent emitted, which is the threshold for NGAS Act reporting. If you have to report under that national standard, you've got substantial emissions. Or you might go further and say, well, it needs to be at the level of 100,000 tonnes equivalent per year, which of course is the level at which the safeguard mechanism kicks in, and it's also the level that's been adopted by our Environmental Protection Authority as triggering environmental assessment. A number of entities that emit greenhouse gases in this state, of course, go well over even that 100,000 limit, 10 times the amount. And so you could say when you get to that level, you are certainly substantial, and that meets the criterion. Now, Ken Berlin has already identified the substantial climate change harm that is occurring around the planet. And we mentioned briefly in the article the growing evidence of climate change harm, losses from extreme events, just think Cyclone Seroja earlier this year, and the gradual environmental degradation from heat and drought. Now, this is important, particularly in the southwest of Western Australia, and coming from a farming background, I look at an example like agriculture, where you've got WA annual broadacre farm profits reduced by 26% from 2000. Sure, we're having a fabulous year this year, but these years, they're the old average. The level of harm from increased dryness, drought, heat is certainly already substantial. So not only is the harm global, it's here. And of course, the forms of harm multiply far beyond the agricultural context. So let's look at the definition then of pollution. And I know that you'll all be fairly familiar with this definition, but it's worth just quickly going through the propositions. Pollution means direct or indirect alteration of the environment, A, to its detriment or degradation, or B, to the detriment of an environmental value, or C, of a prescribed kind that involves an emission. So the emission bit seems fairly significant, but I would suggest to you that it's not necessarily an essential part of the analysis. So although environmental harm doesn't contain that word, we may still have an issue with environmental harm. If we think in basic analytical terms about greenhouse gas emissions and the meagre precedents we have in judicial review on this question, we can say, well, greenhouse gas emissions are colourless, odourless, I think, mostly natural, and their impact is not likely to come perhaps within that ordinary meaning of physically impure, foul or filthy that the Supreme Court cited from the dictionary in the Palos Verdes case. So you might say paragraph A is not going to make it. But if you look at a broader analysis emphasising the words indirect alteration of the environment and think long-term cumulative effects, we can even think of other examples. Asbestos fibres, at one time not recognised as a pollutant. But we now know that after decades, even a single fibre can cause severe disease. Would anyone say now that asbestos fibres are not a pollutant? Perhaps a more benign example, dust. Oh, it's just a bit of dust. But the Kwinana Airshed EPP prescribes limits on those bits of dust. And we know that I've got to get this right, the Ambient Air Quality Monitoring, NEPM, sets standards for particulate matter. We know that even PM 2.5 is a problem cumulatively over time. And so we can say dust is also a pollutant. And so if you take into account the cumulative impact over time, it's not hard to see greenhouse gas emissions fitting the element B to the detriment of an environmental value, which of course includes human health, but also ecosystem values, non-anthropogenic values, non-anthropocentric values. So the forms of harm that are occurring, we could say, could meet this definition, especially if you've got substantial emissions. Now, the department, and I apologise for the acronym, but the Department of Water and Environmental Regulation still uses the view, no doubt on state solicitors' advice, that greenhouse gas emissions are unlikely to be pollution or environmental harm if all that can be established is incremental additions to cumulative global greenhouse gas emissions. Now, this view stems from an appeals committee decision in June of 2015, and I suspect it was based on some of the early environmental impact assessment cases at the federal level, for example, 2007, the Whitsunday case, where the federal court said, well, it's open to an administrator to take the view that you can't identify a connection between a project's emissions and particular harm to individuals. So you could then say, well, it's just part of a cumulative global problem. That view is now, in my respectful submission, legally redundant. So to pursue the reason why it's redundant is we look at the legal tipping point of the Paris Agreement. Note the date, 12th of December 2015. Now, I know, of course, that the signatures had to be made and that the agreement came into effect, I think, in November 2016. But this is a significant date for the legal tipping point, and you'll see shortly why. It set, of course, the temperature goals of 1.5 or 2 degrees. And that, for a reason we can explore by question, sets our global carbon budget and leads to our nationally determined contributions, which set our national budget, and you can even draw that down to a fair share at a state level. If you take the carbon budget analysis, which Justice Preston used in the Gloucester Resources case in 2019, he explains all greenhouse gas emissions contribute to climate change. And there's a causal link between, in that case, the project's cumulative greenhouse gas emissions and the consequences of climate change. And speaking extrajudicially, Justice Preston goes on to say, seemingly minor impacts become unacceptable for vulnerable areas, species and ecosystems. So that little bit of extra globally is a problem, and it is causing harm. So if you use the carbon budget analysis, you can say that cumulative substantial emissions are increasingly harmful, and of course they're increasingly harmful as that budget is used up. Chief Justice Martin, speaking in the Save Willey wetlands case, not a greenhouse gas emissions case, but note the date, 4 days after the Paris Agreement. And he says, acknowledged obiter dicta, in seeking to explain offsets, some forms of pollution may be rendered environmentally acceptable by the provisions of environmental offsets. An obvious example is a proposal which would result in emissions of carbon into the atmosphere being offset, and you can find the quote and read further. So Chief Justice Martin made the step, the transition to a new legal understanding post-Paris Agreement in 2015. Why are the rest of us taking so long? I'd suggest to you that it's time we made that transition. So let's turn quickly then to the definition of environmental harm. And again, I'm sure that you are pretty familiar with this definition. I won't go through all of it. I just want to emphasise the additional element that probably comes from the judgment of Chief Justice Malcolm in the Palos Verdes case, where there's the talk about the alteration of the environment to the detriment or potential detriment of an environmental value. And so if you think about the way greenhouse gas emissions work, sure, when they're emitted, carbon dioxide isn't immediately toxic. But we know that when greenhouse gas emissions, not just carbon dioxide, are emitted, they immediately start warming the planet, right? Immediately. And yes, it does take some time, decades, a bit like that fibre of asbestos, decades to manifest in climate change harm. But we also need, of course, to distinguish here between material or serious environmental harm. Our analysis in the article suggests that at least the large resources projects' greenhouse gas emissions would be material. If you add that potential detriment, then of course, looking to the emissions leading to climate change harm, then you really do have that potential climate change harm fitting the definition. So what I'd suggest to you is that we can say these substantial emissions meet the definitions of pollution or environmental harm. What about the licensed defence? Well, the current section 74AB4, I know it's a mouthful, gives you a defence to offences of pollution and environmental harm if you're acting in accordance with a licence. Now, the interpretation given in the Eclipse case, which I think follows the Macquarie case from New South Wales, basically says, well, a licence permits a prescribed activity on nominated premises in accordance with any conditions on the licence. And so the activity is subject only to the express limits in those conditions. Otherwise, the activity's necessary greenhouse gas emissions are impliedly authorised because the activity is authorised subject to the limits only in the conditions. Now, for a while, the department was adding a note to licences to say this licence requires specific conditions to be met, but does not provide any implied authorisation for other emissions, discharges or activities not specified in this licence. Well, with respect, I think we realise that that note added to a licence couldn't change the interpretation of the Act. And so it's just as well we have the addition to the EP Act, section 74A2, which achieves the same thing. A licence does not authorise an emission unless the emission is specified in the licence as an authorised emission. Well, authorised, what does that mean? And how specified? So, for example, would it be enough to specify that there are discharge points for CO2? Does that authorise the emission? Or that there are monitoring provisions? You've got to monitor the amount of methane that's escaping. Does that authorise the escape of the emissions? Our view is that there does need to be a condition setting an express limit on the volume or rate of emissions. So that express, more rigorous requirement of authorisation with its set limits is the preferable view. So the licence defence, what else could there be? Well, of course, we know that environmental impact assessment has been reviewing greenhouse gas emissions for some decades now, and the current Section 74A, the new Section 74A1A, provides authority for a Part 4 implementation agreement. Sorry, I haven't expressed that very well, have I? It provides authority to conduct an activity by virtue of the Part 4 implementation agreement or decision. And if you've got the conditions relating to a greenhouse gas management plan and abatement plan, you might say you've got your defence, and it's an alternative defence under the Act to prosecution for pollution or environmental harm. But it's apparent that the analysis of the EPA through these assessments has not considered greenhouse gases as pollution or environmental harm. They have instead been regarded as emissions to be minimised. And so you can look at the evidence of the EPA assessments, you can look at the EIA guideline that was issued just last year. It's very clear that the EPA and the Minister in giving ministerial approvals has not been treating these emissions as pollution or environmental harm. And I would suggest to you that acting on an incorrect legal understanding does not give you a defence. And it's only if the Part 4 assessments are conducted on a correct legal understanding that the implementation agreement will give you that defence. And I refer to the ACF and Minister for Environment case. You can see 2021 Federal Court, where the Federal Court agreed that the Commonwealth's Department had incorrectly applied the meaning of coal mining activity in the water trigger under the EPBC Act. So if you apply an incorrect meaning of a core concept, you're not going to make a valid decision. That leads us with one final point. We need to regulate these greenhouse gas emissions. And what's apparent from the Commonwealth's continuing approach to this is they don't wish to regulate greenhouse gas emissions to achieve reductions in emissions. And so the EP Act regulation becomes very important. Thank you.
Thank you, Alex. We'll get you to stand up there and I'll stand down here and we'll have some microphone runners. Thank you, David. Cool. Ladies and gentlemen, any questions? We can get you a microphone. Alex loves to chat about these sorts of things. There are definitely people in the room who have pondered similar questions in the past. We've got one at the back table. One moment, sir, we will get you a microphone. It is on the way. That is Lauren. Can we get a microphone there, please?
I can share this one, Isaac.
Oh, thank you. Thanks, Alex. You talked a little bit about some of the, I think you described it as likely incorrect legal advice that the EPA is relying on when they make these decisions. Is there a reason that that advice has persisted or has not been, updated in light of the Paris Agreement?
I can only speculate, Abdi, in answering your question. Don't forget, the EPA gets submissions from both sides of the argument. The submissions to the contrary of what I might argue probably come from more powerful entities. That's as much as I can speculate. But I'm not in a position really to answer the question.
Wonderful, thank you. Alex, any more questions from the audience? We go, Michael's got one up the front. We have a microphone, it is en route.
Thanks, Alex. Licenses can be for kilns, piggeries, mines, whatever. So say we now start regulating in the license for offsets or emissions. What number do you put on it in the license, do you propose?
What number? Sorry, Michael, just explain that a little bit more. What number? You mean at what level of emissions would you start requiring that there be authorisation?
That, and then you say, okay, you're a piggery, you're a kiln, you're a gold mine. is it emissions per gigajoule or a flat emission number or relative to the industry standard? What's your baseline?
Yeah, so that's probably more a scientific and policy question for those with that understanding to address. My argument is that the Environmental Protection Act provides for these types of emissions to be regulated under Part 5 as well as under Part 4 as pollution or environmental harm. Now, your examples perhaps pose the dilemma. If you've got a piggery, the level of emissions probably aren't going to be substantial in the way that I've defined them. And I do know from a conversation some months ago with an officer within the department, having read the article that we published, the officer said, yes, we're wondering, the simple answer, of course, is prescribed by regulation what level of emissions equals pollution, and that would resolve the uncertainty of where to draw the line. And the officer said, well, we're wondering about the 25,000 or the 100,000. That would mean, of course, that if that regulation were passed, many entities such as piggeries won't be thinking about having to get their emissions licensed. Just to give you a comparative example, talking to a farmer friend, and this farmer is, they have a big farming enterprise, and the carbon audit, or the greenhouse gas emissions audit that they'd done, suggested that they had about 5,000 tonnes a year of emissions. Well, that's way below the level that I've been talking about. So we're really thinking, that you probably need to do a review across the level of emissions that are taking place within Western Australian economic activity, and find the right sort of level that is practical from a resourcing, human resourcing point of view to regulate. And look, I think it probably should go at the 25,000 level, but I don't have a strong view on that. What I would say is that the whole regulatory exercise would benefit from the making of something like a Climate Change Act, where you can actually have progressive emissions reduction targets set and have careful planning around the mechanisms for achieving those reductions. And of course, we could do that through an environmental protection policy under the Environmental Protection Act Part 3. So the mechanisms are already there to do it. There just has to be the political will and the human effort made.
Thank you, Alex. We do have time for one more question to follow up on at the back there.
Hi, I'm Guy. I volunteer with the EDO. I was curious about the application of this argument, whether you'd be looking to challenge upcoming licenses or existing licenses which have been granted erroneously. And if you are looking at challenging existing ones, whether that would only go to licenses made after the Paris Agreement, or whether the argument would stand before.
Yeah, thank you, Guy. Look, it's I'm not quite sure what you mean by challenge. I will acknowledge that I have an appeal into the Environmental Appeals Convener on Woodside's...
Can we not mention specific projects?
Specific
Sorry,
projects,
Alex.
okay,
Yeah,
I
yeah.
won't. You raised that bit. I have made an appeal. But look, the potential, if you think broadly, the potential is that if there isn't movement by government politically, some parties may feel that it's worth a go seeking judicial review. I suspect that newer projects are probably ones that are going to be fresher in the mind of those making decisions, and that's probably the more practical way to test the argument.
Final one, Belinda. We will get you a microphone just for the people online, Belinda, pretty please, and thank you.
Alex, thank you. Very interesting article presentation. I can see a few other things potentially popping into the space as well, based on the logic that you've walked us through today. Just on a slightly different matter, could you not, or could more people not challenge the management or lack of management of greenhouse through just the intergenerational equity aspect of the Environmental Protection Act? You've got the pollution, and that allows an activity which in theory should assist in mitigating or reducing emissions into the future. But doesn't our Act have that intergenerational equity component? And isn't there more opportunity to address the history from that perspective?
I would actually turn the analysis around. As I'm sure you know, Belinda, intergenerational equity is one of the principles of Section 4A, which are described as the objects of the Act. The difficulty is that most of the objects of Section 4A, are not being applied in the regulatory consideration of greenhouse gas emissions, because the emissions are being treated as only, quote, emissions, which is a term defined under the Act. But that term under the Act has a relatively benign meaning. It doesn't in itself carry the concept of harm. It is only really when you equate those emissions with the potential or actual harm that you trigger the full suite of the objects. And then, of course, intergenerational equity becomes really important. And so a decision, for example, that were made that had the effect of authorising large amounts of greenhouse gas emissions that did not consider intergenerational equity, I think would be susceptible to judicial review for failure to consider a mandatory relevant consideration. So I think it's still relevant, but you don't actually get to intergenerational equity until you can fit the right definition in place. Thanks for the chance to talk.
Thank you, Alex. Ladies and gentlemen, our final speaker for the first session is Senior Member Stephen Willey. Stephen is a town planner and lawyer. He's currently a senior member at the State Administrative Tribunal, where he manages the Development and Resources stream, together with Deputy President Judge Parry. Since 2014, Stephen has lectured in the Environment Planning Law at Curtin University. His qualifications including a Bachelor of Law and Urban Regional Planning, with first class honours, and a PhD in Urban Planning. Stephen's PhD was a comparative study of planning appeals systems across Australia and Wales and Canada. Stephen is also the author of The Planning and Environmental Law in Western Australian Text, which was published in August 2021. Stephen, did you bring a copy with you today? Did. Today, Stephen will be presenting on climate change considerations in planning law. Please join me in welcoming to the stage.
Because I was not present this morning, I acknowledge the Whadjuk people of the Noongar Nation on whose lands we gather. I pay my respects to their elders past, present and emerging. Thank you very much for the opportunity to talk here today. I will be brief because I realise I'm the last speaker before a break time. So I'd like to start by having a quick look back. And whenever I'm asked to think about the relationship between planning and environmental law, I always start with this case here, which is from my early time as a planning professional. And it was this case of Squarcini out in Wanneroo, and it was a subdivision proposal, so possibly well removed from the focus of my talk. But the Town Planning Appeal Tribunal in the day found that there were significant environmental issues that were raised by the subdivision, even though the Environmental Protection Authority did not choose to assess the subdivision. And nevertheless, for planning environmental grounds, if you can understand that term, the tribunal refused the subdivision. So the matter proceeded to the Supreme Court by way of an appeal from the developer on the basis that town planning environmental considerations were not town planning considerations, they were not relevant considerations for a town planning body, in that instance the tribunal, to consider. On a close review of the Act, Scott found some reference to environment within the Town Planning and Development Act. And the reference was that when the WA Planning Commission was preparing a state planning policy, it could have regard to conservation and environmental factors. And from that, Scott reasoned that, the environment must be a relevant town planning consideration. The reason why I always pause and look back is that because that is only 25, 26 years ago now, yet the argument was made, and it was a credible argument in its day, that town planning had no business considering the environment. So we have come forward And from that, the WAPC really has gone on an environmental agenda, as it were, within the confines of what the WAPC does, of course. So following Squarcini, we then started to see the WA Planning Commission move into the space of environmental policy much more. There was an environmental and natural resources state policy, and we have the state coastal policy, which was first prepared in 2003. And of course, in 1996, shortly on the back of the Chapel decision, we have the environmental review of planning schemes, the upfront assessment of planning schemes for environmental considerations. So throughout the 1990s, we start to see emerging an emerging link, I suppose, between planning and environment. And town planning has been described as derived from the goals, aspirations and beliefs of a community. And I've also described it as land use and environmental planners as the guardians of the public interest in the land development process. And what I mean by that is that land use planning, environmental planning, is meant to represent the public interest. And it follows from that public interest must include environmental considerations. In terms of our regulatory regime in planning, our Act commenced on the 9th of April 2006, and the objects of that Act included promoting the sustainable use and development of land in the state. This was a first. This was the first time that we had planning embracing environment, particularly sustainability, as an object of what planning seeks to do. Sustainable development is also referenced elsewhere in Estate Planning Policy number 1, which is the overarching state planning framework. But the term climate change, is not directly referenced in the Planning and Development Act. Therefore, at this point, as we sit here now in 2021, in the context of the Planning and Development Act, climate change must be addressed through the prism of sustainable development. And we have seen a number of policy responses from the WAPC which seek to deal with the effects of climate change, such as our state coastal planning policy and also our Bush Forever policy, but nothing, possibly not surprisingly, that deals with climate change more directly. There's no policy made under the Planning and Development Act that deals with climate change mitigation. And I think Alex just mentioned the Gloucester Resources decision, where New South Wales Chief Justice Preston, whilst he was refusing the Rocky Hill mine on other grounds, made the following comment that greenhouse gas emissions of the project and their likely contribution to the adverse impacts on the climate system, environment and people adds a further reason for refusal. Refusal of the project will also prevent a new source of greenhouse gas emissions. But when we reflect on that decision and what it means for us here, we must appreciate the differences between here and New South Wales. An important difference is that mining proposals in New South Wales need a planning approval, whereas in Western Australia they do not. I've referenced there the Mining Act, where that process is dealt with. I've also referenced the fact that Part 10 of the Planning and Development Act generally only does not apply to Crown land, although with some important distinctions. But in Western Australia, the other thing I could have mentioned is we have state agreements. The point I'm trying to drive at here is with these bigger projects, they are really kept out of planning's hands. They are dealt with at a level above the land use planning system. We don't have third-party appeal rights here in Western Australia, and in fact the greenhouse gas emission issue that was the focus of what I just spoke about by Chief Justice Preston was brought by a resident group, an objector group, who joined the appeal. We don't have that power. We certainly don't have the power of joinder in Western Australia. That's specifically excluded for matters under the Planning and Development Act. But we do have a somewhat more limited capacity to allow a party to intervene under Section 37(3) of the SAD Act. But let me just say, intervention is certainly the exception. It is not the rule in planning reviews before the Tribunal. So in the exercise of planning discretion, where does environmental considerations and therefore climate change sit? Well, it arises most often in when we're dealing with development applications. And there's a range of considerations which are set out in Clause 67, subsection 2 of the deem provisions, which are basically a list of 30-something considerations that arise in the exercise of planning discretion. And the following raise potential matters that might bring environmental considerations to the fore. The first is any approved state planning policy, any EPP approved under the Environmental Protection Act, any policy of the state, and I'll reflect on that perhaps a bit later, and the amenity of the locality, which includes the environmental impacts of the development. The likely effect of the development on the natural environment or water resources, and the suitability of the land for the development, taking into account the possible risk to human health or safety. Now, over the course, since 2006, when the Planning and Development Act started, there have been possibly 7 or 8 decisions where environmental considerations have been at the fore, but really only 2 or 3 where you'd say that it was more climate change considerations that came that were relevant in the exercise of discretion by the tribunal. The first one I'd like to talk about is the Mount Lawley case. Now, this was a sand mining proposal, and what the concern was from the developer was that they wanted to access their resources for their own purposes, where Main Roads wanted the same sand for its purposes. And the argument was put to the tribunal that if the proposal was not supported, then the developer would have to source that materials from elsewhere, and that would have carbon consequences, I suppose, in terms of that additional transport, because what they wanted to use was on site. And the point coming from this is the tribunal pinned sustainability to this concept of orderly and proper planning. And it said since the commencement of the Planning and Development Act, environmental sustainability is an aspect of orderly and proper planning. And orderly and proper planning has been discussed in detail by Justice Pritchard in the case of Marshall and the Metropolitan Redevelopment Authority. But the point about it is orderly and proper planning is a consideration that applies across almost all planning proposals at some level. So what the tribunal was saying is that as an aspect of orderly and proper planning, developments must be environmentally acceptable. The next case that raised carbon reduction issues was the well-known case of the 2 concrete batching plants in East Perth. They operate on time-limited approvals, and every 5 to 7 years they end up before the tribunal. Now, the issue at this time is that the local authority wants something else to happen on their land, on that land. The idea of having 2 concrete batching plants is not really consistent with the vision that the local government has for that particular locality. These concrete batching plants have been in place for a while now. But what the argument was before the tribunal was, well, if these aren't here, and they service most of the big developments that happen in the CBD, the concrete pours are at night. The concrete is a different kind of concrete than you might use on a residential house. It dries quicker, has to be on site within 20 minutes, all these kinds of considerations. But for present purposes, the relevant point was that if these weren't there in East Perth, nice and close to the CBD, then they would be in Osborne Park or somewhere more removed. And every time there was a build on, the carbon emissions or the carbon issues associated with the transport requirements of having those concrete batching plants further away from where they're needed would have a cumulative effect. So through that prism, the tribunal looked at the question of sustainability in that instance. And most recently in Robertson in the city of Albany, this was to do with an extractive industry on the NELA WA Peninsula. The tribunal allowed the application in part because this was going to be a local source of product for this material, whereas at present, at the time of the hearing, this material was being sourced from Margaret River. So again, focusing on the question of carbon reduction, the tribunal allowed the proposal on the basis, in part, that it would result in less transport needs being required to service that kind of good for the local population, and therefore there was some environmental benefit within that. That really is where things sit in terms of planning law and climate change. Climate change is not yet an express consideration that arises in the exercise of discretion. And I say not yet, in my role it's not for me to speculate as to whether that will happen or not. But at this point in time, we deal with climate change as an aspect of sustainability, as we are directed to under the Planning and Development Act. The Tribunal itself now regards sustainability as an aspect of orderly and proper planning. And what I would say is that any policy of the state has to be given due regard by the Tribunal, and that may mean in time, if there is a climate change policy that's adopted that has specific mitigation aspects to it, well, that will need to be considered by the Tribunal and applied on its terms, again in the context of having due regard. And the final point I'd like to make is that sustainability, climate change considerations, these all have to be balanced out. And the point I'm making, I suppose, at the moment is we're seeing a whole lot of, I think we would all agree, a denser, more compact urban form will have environmental benefits. And in the western suburbs at the moment, what we're seeing now is proposals for greater density, which at an environmental level would be good because they would reduce transport costs and associated things like that. But from the social side of things, there's concern in those communities about what that development might look like vis-a-vis what the amenity that they've come to enjoy and share. So my point is that these things all have to be balanced out against each other in terms of environmental benefits versus the social implications from those kinds of developments. But really, that's all I wanted to say. Thank you for inviting me.
Don't go too far this Stephen. We'll get you to stay at the front for questions while you have the lectern. We have a mic ready to run. Have we got a question that needs to be answered from our audience? Lee, thank you.
Hi. I'm just picking up on Alex's point before, the Justice Martin statement that greenhouse emissions can be offset. Wondered in the SAT cases you've talked about whether that's a consideration that applies in planning law, whether you can say, well, yes, there'd be more greenhouse emissions from transport, but that's something that can be offset. Potentially. It has not come, it's certainly in my time at the Tribunal, none of those cases that I referred to are the ones that I have dealt with. Certainly the argument could be there, made in those terms, and yes, I mean, potentially. I mean, that's probably, it's not a great answer, but it's the best answer I can give you.
Excellent. Have we got any further questions from the audience, ladies and gentlemen? We've got one down the front from the lovely Sarah.
So this is also a case that you haven't mentioned in your presentation because you didn't sit on the Tribunal at the time, but the Tuvok case that was decided in 2019.
Yes.
So that created a lot of excitement in terms of the consideration of sea level rise in those decisions. What do you see as being the flow-on consequences of a decision like that for the Tribunal? Do you think that those issues will keep coming up, and do you think that that kind of demonstrates a shift in the direction of those decisions?
Yeah, I deliberately stayed away from Two Rocks because I was junior counsel for the state on that matter, but I didn't get through to the final hearing. I was appointed to the Tribunal in the meantime. But it was a very important case in the context of dealing with the effects of climate change. Very interesting case with a very interesting history. What it will mean, what I think the Tribunal ultimately did is pinned its sail to the mast and said climate change is important, and showed a willingness to uphold policies that give effect to that. In the context of a state which has 21,000 kilometres worth of coastline, I think that was an important decision.
Thank you. We have an online question from Peter Brazier. What is the implication of climate change being included in the bushfire SEP mapping? SPP 3.7.
Yes.
Yes.
What it will mean for the Tribunal is, it would be my guess that you'd probably see more in terms of what the mapping produces and what it shows. That informs the regulators as to the kinds of decisions they're going to make on particular developments or subdivisions. And what that may mean is that we may see more cases coming forward where bushfire risk is a relevant consideration that needs to be
weighed in the balance. My point is we probably will see more of them the more conservative that bushfire mapping becomes.
Very good, thank you. Mr. Alex Gardner.
Stephen, thank you for your presentation. Can I go back to Lee's question and ask if you could explore offsets under the planning legislation a bit more? And I acknowledge that I really don't know that much about the Planning and Development Act, but I imagine one of the old planning law obstacles may be that conditions imposed on a development approval must pertain to the development. And yet I assume that an offset is going to require some activity elsewhere. Is that a problem?
It's a very good question, and one I don't have a very good answer for, but because it arises in this way. A development application is generally made on one parcel of land, and you're dealing with that parcel of land. Now, the extent to which you can have regard to what is happening on another parcel of land to mitigate what is going on and what is proposed on this is a question I would refer to a judge, basically. No doubt, in the fullness of time, it'll be a debate that has to be had, because how do you assess the full impact of the development without having regard, in fairness, to what is being done elsewhere to mitigate its impact? First principles would suggest you could do that, but it is untested, and therefore I'm nervous going any further.
And I don't think we have any judges in the room today, unfortunately. Wonderful. We do have time for another question. Follow up. One from me then, Stefan. It seems as though the planning policies seem to be looking at adaptation. Are we seeing an appetite from the WAPC to be directly addressing mitigation of greenhouse gas emissions?
Yes, well, that's really a political question. What I would say, yes, is what we're seeing in the space of state planning policies is reaction to climate change events. Whether it is the WAPC's charter to go any further than that, that's really a political question, and I'm not brave enough to answer it.
Very good. Marina.
Hi, Stephen. The cases that you've mentioned have quite a local focus, yes, in terms of impact and the outcome of the tribunal. Do you think that arises in part because there are no third-party appeals which raise broader issues, and so the decision makers often looking at amenity in terms of amenity of neighbours, as opposed to balancing environmental factors on a broader scale? Yes,
I think it's the lack of third-party appeals in Western Australia is again a political issue, but to the extent I'm speaking for myself, and in this comment I am, there's a solid argument for them, a sound argument for them. If and when they happen, I think you will see more environmental challenges being made to the tribunal, and the tribunal will be directed to deal with those issues much more directly than it currently does on the issues that arise between the parties. But unless and until that point is reached, we are going to be, to some extent, relying on the issues as between the parties, and as those bigger projects where climate change is perhaps a real issue, and they simply don't come to the tribunal under our regime at this point. The cases I'm referring to, yes, they're all local. They're all, marginal improvements in the jurisprudence because they're very local decisions.
Wonderful. Little segue there. NELA did a discussion paper on third-party appeals and planning law a couple of years ago as a result of the 2017 State Conference. If you haven't read it, it's available, I hope. Any other questions? We have time for one more before we all have morning tea. Very good. One in the middle.
Hi, I'm Sue Waite. I'm a student at Murdoch University. I also work as a Natural Environment Officer in local government, and this is more of a comment actually rather than a question, if that's okay. Just in regards to mitigation, I see, excuse me, a bit nervous actually, just how WAPC is involved in the DPLH funding of the CMPAP grants to local authorities to develop coastal hazard risk management and adaptation plans, for example. So I guess there's other ways in which they're involved in being able to help reduce, I guess, risk to coastal erosion and inundation, for example. So yeah, I think there's other things that are being done which are quite helpful. I know because I work within a local government, and we're currently going through the CharMap process at the moment, and it's quite helpful. So, and we'll be guiding development and planning in our area.
Wonderful, thank you. All right, ladies and gentlemen, unless anybody has a final question, let's call morning tea. We will usher you, it is just out here, all of these doors are openable if they're not already open for you. We will reconvene at 11 a.m. for session 2. Thank you very much.